Okay, we'll get started with our final presentation. Judge Spencer is graciously pulling double duty and staying on for the next section, which will be moderated by the Honorable Jacqueline Talevi, the Chief Judge for the Roanoke County General District Court, and by the Honorable Denis Soden of the Henrico Juvenile and Domestic Relations Court. Judge Talevi received her undergraduate education from Virginia Tech, we call it now, it's on the resume, VPI and State University, but and also went on to Washington and Lee. She was admitted to practice in not only Virginia, but also West Virginia, and came to Roanoke in 1983 and ran the Office of the Public Defender. She was the Chief Deputy Public Defender before she went on the bench in 1996. I have appeared in front of Judge Talevi, and it's always a pleasure to be in her courtroom. Judge Soden sits here in Henrico and attended Hampton-Sydney and the University of Virginia School of Law. Most recently, Judge Soden was made a member of the Hampton-Sydney College Athletic Hall of Fame in basketball. Prior to going on the bench, he was in private practice for 28 years and practiced in the areas of family law, trust and estates, and real estate. And so please welcome these three who are going to talk about probably the most important topic of the day, courtroom civility and etiquette. Thank you.
Thank you very much for inviting me to speak with you today. I have the dubious distinction of being the moderator, and actually it is a distinction to serve with Judge Spencer and with Judge Soden. I want to talk with you, and we want to talk with you this afternoon about civility in the courtroom. What does it mean, and why does it matter to you? You know, in our country today, the perception among courts and columnists and legal journal authors and conference organizers such as this is that incivility, rudeness, and the use of offensive tactics among lawyers is on the rise. The public's perception, too, perhaps shaped by television, is that lawyers are untrustworthy, deceitful, and manipulative, not only in their relationships with the public, but in their relationships with each other and with the court. What has happened? Have client perceptions and now their expectations changed so dramatically that now the client believes all lawyers should be as aggressive as the lawyer portrayed by the newest television drama show? And is troubling, does the lawyer believe this is his role as well? You know, we sometimes hear the terms professionalism and ethics spoken of together as though they are the same, but they're really quite different. Ethics tells us what we must do to keep our license, the minimum standard of conduct below which we must not fall. Failure to follow those rules as set forth in the Virginia Rules of Professional Conduct will result in sanctions, suspensions, and perhaps revocation of your license to practice law. On the other hand, professionalism teaches what we should do as we practice law. Civility is more than surface politeness. Rather, it is an approach to the practice of law that seeks to diminish rancor, to listen to one another, to reconcile, and to be open to a resolution that doesn't involve a week-long trial. Civility urges lawyers to embrace your role as an advocate, to cooperate, collaborate, resolve conflict, and settle that dispute. And civility also urges you to embrace the role of counselor, because you know you are an attorney and counselor at law. So give your client the advice and the guidance that your client requires. Don't just say what he wants to hear. You're not fulfilling your role as counselor when you do. What are the boundaries of civility? When does incivility rise to the level of unethical conduct, and when is it just harmless, rude, and then acceptable behavior. What behavior is so egregious that it is sanctionable? And what is acceptable under the rubric of zealous representation? Sometimes it's difficult to know where that boundary is. Fortunately, the two judges that are serving on this panel with me have a wealth of experience in just this very issue. So I'm going to ask Judge Spencer now to share some insight with us, some of her experiences, and then Judge Soden will do likewise. Judge Spencer.
Good afternoon again. I'm going to start with a little history. I'm going to have to tell my age. I graduated from the University of Virginia School of Law in 1972. There were no ethics courses. There were no professionalism courses. There were no clinics at the University of Virginia School of Law in 1972. What happened? Why do we now have mandatory ethics CLE? Why do we now have a professionalism course that all new lawyers are expected to take? Why do we now have so many clinics? Why do we now have ethics courses in law schools? What happened between 1972 and 2013? Well, the economy happened. Well, television happened. But I think people change. People change. Fortunately, I have been very pleased with the level of civility and the level of professionalism I see in circuit court here in the city of Richmond. And I'm going to tell you a couple of things that you'll hear from other courts. I want to tell you one of the big issues that I see, and I see a big change in the last 15 years. And I think people change and lawyers change. But I don't think we have the problems now that led to the problems that caused all of the mandatory courses. We didn't have them in 1972. Nothing was mandatory. And one of the big issues, and one of the points that I think you've heard a little bit about today is discovery disputes. I think lawyers have a problem generally with discovery, particularly in circuit court. I refer to discovery as looking for love in all the wrong places. As a lawyer, you're trying to get something that you need, something that will help your case from the one person who does not want you to have it. And most of the civility issues, most of the professionalism issues, I think, that led to this growth in mandatory ethics, mandatory professionalism courses, started with discovery. They started with rules, started with discovery disputes. But fortunately, I don't see as much of it now. I don't think it's because everything is mandatory. I think it's that people have changed. And you are very smart. You can't do what you see on television. You ask any judge in the Commonwealth if they like the judge shows, they will tell you no. We don't like the judge shows because the judges are rude, they're disrespectful. We don't like the way they talk to litigants. And I think lawyers are at that point now, too. You don't like what you see on television. But if there's one area where I think you need to be careful, it's discovery disputes in circuit court. What can you do? I have three things to suggest. One, education. Anytime you can take a course online, any CLE on education, discovery, training for lawyers, do it. Learn how to get information that you don't have to go to the wrong place to get. Learn what you can do with a subpoena duty statement. Learn what you can get without going through the very one person in the courtroom who does not want you to have anything. So any education you can get about discovery, if you're having a problem with something, get education. The second thing, and you've heard this before in the other sessions, a mentor. There are, I hate to say older lawyers because we aren't older, we're just seasoned. There are seasoned lawyers that you can talk to who are well respected by the bar, and don't be afraid to ask for advice. Don't be afraid to say, I'm having a problem with lawyer so-and-so. We're trying to schedule a date for a deposition and he just will not do it. What should I do? Don't be afraid to get advice. And the third thing, in terms of courtroom civility, is don't be afraid to come to court and watch and observe. I think people watch too much on television. Everything now on TV is either a lawyer show, a cop show, or a reality show. And I think at times you're trying to please your client. You have to please yourself and do what's right. And if you need to come to a courtroom and sit down and watch and see how it's done, when the seasoned attorneys are doing it, don't be afraid to do it. So those are my 3 pieces of advice. Get education, training. That's why you've been in school all your life. You understand the value of education. It does not stop once you become a lawyer or once you become a judge. It is a continuing process. Get a mentor. Don't be afraid to seek advice and observe good practices. Sit in on a deposition. Observe good practices. Go to court. Observe good practices. So you can put out of your mind what's happening on television, and you can explain to your clients, this is what we're going to do, this is why we're going to do it. So nobody expects you to be rude. When people come to court and watch us, they say it's boring. High school students come, college students come, they say it's boring. Just because you didn't yell at us, you didn't do this, it's boring. It's realistic, it's life. We aren't there to entertain anyone, and you all are not there to entertain anyone. You're getting paid to be a professional, to be a counselor, and my advice is just act.
Thank you, Judge Spencer. Judge Soden?
Thank you, Judge Talevi. I would be remiss if I didn't say that I think in all of our comments, even though it's geared more toward civility in the courtroom, it carries over to civility in the general practice. So whether you're doing customs-based work or taxation, family law, criminal defense work, whatever it might be, rules of professionalism and ethics obviously apply to all of us. So your reputation is honed by how you treat other people and how you're courteous to other attorneys. And believe me, even though judges are isolated to a certain extent, we don't get to interact outside the courtroom with a lot of people or attorneys. We hear things, we observe, we talk between ourselves as to who did what, who blew the case, what they did wrong sometimes. And so we know, and we can appreciate you all when you come in, and if you've been punctual, if you've treated the court with respect, then that gets around, those positive comments. So, that's how you can build your reputation. But and maybe giving you a few examples of what I think attorneys need to do, it brings up a story about a gentleman who went into a high-tech restaurant, and the maitre d' actually was a robot. And the robot put to attention and said, "Sir, you have about an hour wait. I'll be glad to converse with you at your table while you're waiting." And he said, "Okay." And so the robot clicked a couple more times and said, "What's your IQ?" And the man answered, "Oh, about 164. Well, then the robot proceeded to talk about interstellar space travel, latest medical breakthroughs, theory of relativity. And so the man was most impressed. So he came back the next day and thought he'd try it again. So the robot asked him again, "What's your IQ?" He said, "Well, about 100. And so this time the robot was talking about NASCAR racing and basketball scores, things of that nature. So finally the man said, "Well, I might as well go for the trifecta. I'll come back the next day." Sure enough, he did and was asked, "What's your IQ?" And he said 50. And the robot quickly responded, "How about them Hokies?"
I knew that was coming. I knew that was coming.
I can't help myself. Those of you, as you can see, I'm wearing orange and blue. The Cavaliers pulled one out last night against Duke, so I've been floating around today, so it's been great. Another story that will illustrate what attorneys need to do, and that is, there was a fellow in the VCU library recently. He asked this young lady who was sitting there, "Do you mind if I sit next to you?" And the girl replied with a loud voice, "I don't want to spend the night with you." All the students in the library suddenly looked over and were staring at the guy, and clearly he was really embarrassed by all this. And so a couple of minutes later, the girl walked by his table and said, "I study psychology, and I know what a man is thinking. I guess you felt embarrassed, right? The guy then responded in a loud voice, $500 for one night? That's too much. Everybody started looking at her, and she was just in shock. And he whispered in her ear, I study law, and I don't know how to screw people. Screwing people, so to speak, should not be your mission in life, but practicing law efficiently with passion, with principles, and keeping your reputation and integrity intact is the way you need to pursue it. So, and was Craig Cooley on the program earlier doing criminal defense? Okay. I'm glad you had a chance to listen to Craig. I will tell you that if there's ever a model of decorum in the courtroom, it's Craig Cooley. And he's one of the most highly respected attorneys, at least I think by the judges as a whole, but by his peers in the bar. And he's very bright, but aside from that, he's competent, but he's very modest, he's humble, he comes into court prepared, extremely courteous to everyone in the courtroom. And believe me, he is most effective. Most of you, he may have talked about the Malvo case. Did he talk about that? He represented the juvenile in that case, but did a tremendous job. And but that's the kind of person that I would want to be if I was practicing law, because he enjoys an excellent reputation, but does it in the right way and doesn't cut corners. There was another story involving a doctor, a lawyer, a young boy, and a priest. They were out for a Sunday afternoon flight on a small airplane. The plane developed engine trouble, and all of a sudden, in spite of their best efforts of the pilot, the plane started to go down. The pilot said, look, I'm getting out of here. He grabbed a parachute and said, look, there's only 3 left for the 4 of you. Figure it out. And he jumped out. The doctor grabbed one and said, look, I'm a doctor. I save lives, so I must live. And he jumped out. The lawyer then said, look, I'm a lawyer, and lawyers are the smartest people in the world. I deserve to live. And so sure enough, he grabbed a package and jumped out. So then the priest looked over at the little boy and said, I've lived a long and full life. You're young and have your life ahead of you. You take the last parachute and live in peace. And the little boy handed the parachute back to the priest and said, not to worry, Father. The smartest man in the world took my backpack. So, arrogance, humility. All right, that's the purpose of that. It's very interesting for me to observe after a case, and I didn't like to lose. I played ball in college, and I like to compete, and so I got up in people's faces. I'm sorry to admit, but I really thrived on that. Same thing in the courtroom, but at the end of the day, I would always shake the other attorney's hand, win or lose. And I think that's part of being an attorney, is learning how to, let's say, take your lumps graciously. It's not about winning and losing, it's about how prepared you were. Did you present your case to the court? Once it comes to us, it's out of your hands, so to speak. So we're the ones that will mess up your case. And I know I've been blamed in a lot of cases. That judge must have been asleep that day. He didn't hear anything. But, that's part of it. But for you to, let's say, after a case, if you won, to maybe jump up on the counsel table and start doing a little dance like you were in the end zone or something, that's probably not acceptable in most courtrooms. So, and it just rubs it in the other attorney's face. So learn to win and lose with dignity. The tough part is, I think, the clients think that unless, and as Judge Spencer mentioned, with all the TV out there, they think you've got to be rude and aggressive and interrupt people in the courtroom. And that's not the answer. That doesn't win you any points with the judge, I can assure you. And clients think you're not doing your job sometimes if you're not yelling and screaming and beating on the table. Well, you have to do what ethics and professionalism allow you to do. And, it's not those things. So if your client can't understand that, you need to tell your client, take a hike. And that's tough to do sometimes, but you just got to have an understanding up front. This is the way I do things. And sometimes clients, believe me, expect you to do weird things. I got accused a lot of times of being in cahoots with the other side. I've had 3 or 4 clients over the years ask me, Did the other side pay you off? Why are you talking to the other side? Why are you trying to negotiate a resolution? Well, my answer was, because I'm trying to look after your interest. I don't want you to lose it all, and that's what's going to happen if we litigate. But, you know, you can't do much to change your client's opinion at times like that. So sometimes you have to have a parting of the ways. So don't hesitate to do that. All right, I'll take a break if you want. Something else?
Well, you're doing so well. I mean, you're staying away from the Virginia Tech jokes, and I really appreciated that. It was only one.
They'll be back.
But, go ahead. Yeah, sure.
Yeah, looking at the principles, I guess what strikes me, when you read through the principles of professionalism, to me it really comes down in many respects to adhering to the golden rule. You know, treat others like you want to be treated, and especially other counsel, but it applies to your client, to other counsel, and to the court. And some of the ones that jump out at me are act at all times with professional integrity, so that others will know that your word can be trusted. It's very, very interesting I know when I was practicing, there were several attorneys that you would not take what they said at face value. You would want to, otherwise you could not believe them. And I was thinking, that's an awful way to be, to have a reputation out there that you could not be trusted. Treat everyone like you want to be treated, with respect and courtesy. As to your clients, explain to your clients that your courteous conduct toward others does not reflect a lack of zeal in advancing their case, but it's done to enhance their case and enhance their interest with the court. It always amuses me and confuses me at the same time when people come in on a custody case, for example, and you know, one side is saying, well, I'm a little more even-keeled, you know, he tends to scream a lot. Next thing you know, the father's testifying, and he's getting all worked up. He's yelling all of a sudden at his wife, and I'm saying, sir, please sit down, I'm going to hold you in contempt. And he continues to yell. And finally, whether I hold him in contempt or not, the point is, here he is in front of the person who's going to make a decision on custody and possibly affect his relationship with his children for the rest of his life, and he can't hold it together enough in court. So what does that tell you? You know, it really makes him suspect as far as being a proper custodial parent. So you really got to get your clients under control and you know, really push them into a posture of, you know, staying as calm as possible. And so often we'll see on TV, and I don't know how many times I've told people in court, this is not court TV. We are not going back and forth. You don't get to interrupt the other side or me. And so sometimes once I start talking and possibly delivering my opinion or making a comment, they may interject something or interrupt me, and that's not the thing to do. I pride myself on having a lot of patience and trying to keep myself under control on the bench, you know, but when that happens, then I'm very abrupt and firm with them and say, you don't want to interrupt me again. This is my time. I get a chance to speak. So you sit there and you listen. And most times they'll do that. But if they don't cooperate, then we have other arrangements we make for them. But as far as the judges go, don't offend the dignity or decorum of the courtroom. I know it seems to be the trend today. Everybody maybe is a little more casual in their dress. But I really don't need to see a lot of a young man's underwear when he comes in. And so all the sheriffs, or I will say, pull your pants up, you know, and you know, get them up where they should be. Tuck your shirt in before they come in. Sometimes, and unfortunately, people have not been exposed to being respectful toward others, and no one's told them the right way to do it. And so we try and instill that so that they have a better appreciation too for what goes on inside the courtroom. You know, if other counsel is being unprofessional to you in the courtroom, then it's the judge's role, and that's why he's there, or she's there, to keep that under control. And possibly if you feel like it's getting out of hand, ask the judge for a 5-minute recess and a chance for the attorneys to talk to the judge, and then say your piece, you know, at that point. But usually the judge is going to maybe take a recess on his or her own and call you back in his office and address those issues. So you don't need theatrics in there. You need to just present your case in the best way you can. Get the facts before the judge, and all of you learned in law school, facts are what make a difference, and that's what you've got to work on when you get in there. All right, thank you. Judge Worthy.
Judge Spencer, anything else you'd like to add?
No, the only other thing I'd like to add is that there are times when you are faced with attorneys, no one in this courtroom and no one that we know, other jurisdictions, who are, there are attorneys who are trying to impress the client, and how you respond to them is important. You have no control over the way other people treat you, but you always have control over how you respond to those circumstances. And my advice is always to take the high road. And I know some of you, you're obviously young and you don't like being what you would call mistreated, or he was rude to me, or did you hear what he said to me, but you are a lawyer, you are an attorney in the Commonwealth of Virginia, and that. So how you respond to rudeness, how you respond to someone else who is impolite or disrespectful is very important. Judges notice it. It is never proper to say, well, he did so-and-so, well, this happened before. You take the high road and you move on. And that's my last piece of advice. I have a question at 4 o'clock. Any of you would ever want to come and serve in the Richmond Circuit Court, contact us, our phone numbers are you. Listen, and I'm happy to have you observe. Thank you very much.
Thank you, Judge Spencer, for your time. I just wanted to add a few closing remarks. I sit in the General District Court in Roanoke County in the city of Salem, and I also sit in Roanoke City. And one thing that you should know when you practice in the General District Court, and I hope you will practice in the General District Court, and that is that we are volume driven. It's nothing for me to have 200 traffic cases to try between 8:30 and 12 o'clock. And I need for you to be prepared. And every General District Court judge needs for you to be prepared. And that is one aspect of civility, is showing respect for the court by being prepared. When your case is called, that you come forward with your client and you sit down at counsel table and you begin the trial of your case. You're not looking around for witnesses, you're not looking around for your client. Sometimes that does happen, but you try not to let that happen. You want to be prepared, that is showing your respect for the court. Also, don't overbook yourself. Even though I have 200 traffic cases to try in the morning, I'm probably going to call your case first. And if you're not there at 9 o'clock when the court begins, then that's another disrespectful indication, and you're building a reputation with me, and it's not one that you want to build. So make sure that you're there on time and that you are not overbooked and have to be in another court. Now, having said that, I'm not unmindful that if you're practicing law as a solo practitioner, there are going to be times when you're going to balance and try to get from one courtroom to the other because you have to make money. I understand that, but make certain that you can do it all. And if you can't do it all, just choose one, because you're going to make somebody mad. And you don't want to make the judge mad, because as Judge Soden indicated, you're developing your reputation. You don't want judges to sit around and talk about you, that nice young lawyer, but he's late all the time, or she's unprepared all the time. I'm really rooting for her, but she's unprepared, or she doesn't know who her client is. While you will talk about judges, go back to your office and talk about what bonehead decisions we made, we talk about you. And we are talking about not only your brilliant trial strategy, but we're also talking about the way you presented yourself. If you roll your eyes, if you give one of these sighs after I make a ruling, I note that. I don't call you on it, but I note it, I store it away. It's one little indication of your lack of respect for the court. You're not always going to agree with what the judge does. Your remedy is to appeal, not to roll your eyes, not to give a big sigh, and not to look to your client and make some sort of sign. You know, your client is watching your reaction. If you are rolling your eyes and are devastated by the court's ruling, your client is going to model that same behavior. And guess what? It's your client who has to obey the court order. So you want to make sure that you explain to your client pre-trial, and as many times as you have to, this is the way we behave in court. The judge may not rule our way, but that's why we have a trial. What we're asking the court for is a fair and impartial hearing. And if we don't win, we note an appeal. But we don't roll eyes, we don't sigh, we don't kick the table. That is unacceptable conduct. And if you have that kind of conference with your client, especially those that are a little high-strung, and let's face it, who isn't a little high-strung? If you're facing a DUI charge, or if you're facing some other charge for which you could go to jail, that client is going to be a little high-strung. You need to have that conversation. You need to have that conversation with the client, not while you're sitting at counsel table with client, but in your office before you get to court, so the client knows what the expectations will be for his behavior. I'll also say that I have seen, when I practice law, discovery abuses that Judge Spencer was referring to. In preparing for this program this afternoon, I read a number of articles about lawyer behavior during discovery, and it was appalling. Obstructionist sorts of tactics, instructing a deposition witness not to answer the question, cursing at the other lawyer in front of the witness that's being deposed, shoving and pushing the other lawyer, grabbing neckties. It was just astounding behavior that is not acceptable on the playground for 5-year-olds, much less for professional people. And while the stakes are high, and I understand all that, you are still a professional. You are still an educated, trained person who is advocating for your client. And when you've lost your objectivity by beating up on opposing counsel, then you have lost your representation, your edge of representation. You have lost the training that makes you a good lawyer. So don't confuse zealousness and over-the-edge kind of behavior with good representation. It isn't. And ultimately, in my view, you jeopardize your client's case when you lose your objectivity and become unprofessional. I practiced law as a public defender for 13 years, and my clients didn't always like me, and they didn't always like what I had to say. And there were times when tables were overturned and I felt that I was in jeopardy of a physical injury. But I never retaliated back to them. Never. Because I am a professional, and so are you. And when things get a little rough, that's the time when your professional training kicks in, and the person that you are, and as Judge Soden indicated, the golden rule should kick in, not only with opposing counsel, but also with your client. Because oftentimes your client is the one that's most difficult to control. And you have to be able to do that when you're in the courtroom, when you're trying cases. Judge Soden, did you have anything else that you'd like to share?
Just a few things, yeah, just to be sure. When you, and Judge, I think Judge Talevi or Judge Spencer may have mentioned about coming out and observing other counsel in the courtroom. Well, don't ignore the coming out and observing the judge. Find out what the judge's propensities are. Talk to other counsel. See if I send people, to jail every time on a given type of case. Not that that's going to completely predict what I do, because half the time I don't know what I'm going to do. But the point is, get there, observe, know what your case and your judge is all about also. And if you're sitting there, if you do come out and do that, or even the day of your hearing, especially me, I'm getting older, I'm older than Judge Spencer, and so my memory gets fogged up, and I may forget a face or a name. So don't hesitate initially, if you've already been before me, to say, Morning, Judge, Bob Smith, I'm here on behalf of so-and-so. Let me know your name, or come up as you come into the courtroom, hand the deputy your card or something, and so that I can see your name. I can tell you, it gives your clients a lot more comfort if they see the judge calling you by name rather than counsel. What do you want to do? Or, all right, Mr. Johnson, what do you want to do on behalf of your client? You can proceed with direct examination. So I think it makes it a little more personal for you and shows your client that there is a respect coming from the bench. The court knows who you are. What happens when do you stand or sit when you address the court? And what do you think? Let's have a show of hands for those who think you should always sit when you address the court. Raise your hands. Well, I'm lazy, okay? That's why. No, I'm only kidding. Your answer is correct. You should stand, give the judge the option to tell you not to get up again. All right? And each court is different. Probably 95% of judges you'll appear before will expect you to stand no matter what it is. And if the judge sneezes, you may want to stand, but in some courts. But in other instances, the J&DR court is a little bit different. It's less formal. Usually, the only people in the courtroom are going to be those involved in the immediate case. We don't let the general public come in unless it's a special situation. So, in those instances, I'm going to be a little less formal also. And so if I tell counsel after they've stood up initially, and for most objections, I'll expect them to stand. But if they're questioning their clients, if they want to argue from being seated where they have notes available and all that, I have no problem with that. And that's me. But again, that's where you need to find out what the judge is usually going to allow in a given case. As far as projecting time needs, when you come in, and I had a case recently, and this was a very experienced attorney, and we had set aside 3 hours on this custody case, and we enter a pretrial order in most cases. And I would suggest to you, think about that, of getting pretrial orders entered, even at our level, because in there, it's going to tell you pretty much cutoff dates. It's going to tell you that in many cases, we want a witness list, at least a projected list, turned in to us and the other counsel 10 days in advance. We want your answers completed no more than whatever, it might be 20, 30, 45 days before the hearing date. But we'll also have a clause in there saying, if you fail to comply, if you don't do some of these things that we've required you to do, then we're going to keep out your evidence at time of trial. And that could be a real embarrassment to you. We hate to do it, but each side has had that pretrial order. They know what to expect, and so at that point, we're going to enforce it. But in looking at time constraints, in this case, everybody had 90 minutes each side. Well, the attorney for the mother took probably 75 to 80 minutes in cross-examination of witnesses for the other side. And so then it got down, I kept telling her, you got 25 minutes, you got 20 minutes left, 10 minutes. She said, 10 minutes? And she hadn't even put her client, the primary person, on the stand yet. And so 10 minutes was up, and I said, I'm going to give you 2 more minutes, that's it. And then I pulled the plug. And at that point, they barely got in the evidence they needed to get in, and to give me some better idea as to how I should handle, make a decision. So be very careful about how you allocate your time. Don't show up for a 30-minute hearing for you with 10 witnesses. It's not going to happen. So what you've done is aggravated a lot of people who took off from work to come to testify, and the likelihood is they're not going to get called, because I'm going to look at them and I'm going to say, if the other side will agree, you can proffer maybe what you think 3 or 4 of these people are going to say. A lot of times they'll bring witnesses, all of whom will say the same thing. She is a wonderful mother. She loves her kids, great cook, takes them to all their activities. I don't need 10 people to tell me that. I'm assuming I'm going to hear that at some point, throughout the afternoon. So don't waste your witnesses, but allocate their testimony and time. Again, as far as scheduling cases, there was an attorney who had 3 months earlier had come in, wanted a contested date. We gave him a 3-hour time slot one afternoon, which is a lot of time for us to give up. The day of the hearing, everybody else is there at 1 o'clock, and he's not. And we get a call that he's tied up in another jurisdiction on a case, and that he's running a little late. So then we get a call an hour later. He's still tied up. And so finally, I said, you know, I continued the case at that point, sent everybody else home because I didn't know when he was coming. But he finally showed up 2 hours late. And I asked him, I said, why did you schedule the other case? This case has been set for 3 months. It's on a contested docket, which is like pure gold trying to get that time. And he said, well, I got a call on this other case after I said it. Well, you don't accept that case. That's the simple rule of thumb. So it's funny, and I don't do this very often, but I held him in summary contempt, and I gave him 10 days in jail, and I sent him to the back. Well, I knew I wasn't going to keep him in there 10 days, but I suspended 10 days after a 4-hour stretch with him sitting back in lockup. I brought him back in, and it's incredible the enlightenment that he saw during that period of time. And so he's very apologetic, and ironically, this happened probably 8 years ago, and to this day, he's always there early for his cases. So, I hate to go to that extent, but you know, you don't want to get into that situation. And I'll be 2 more minutes. Can I do that?
Absolutely.
Okay.
Take as much time as you need.
No, they'd love to get out of here, I know. But on court-appointed cases, if you're on the court's docket, whether as an attorney or a guardian ad litem, we now, and Henrico have gone to a deal where we set up a file on the attorney, and we have them sign some acknowledgement up front once they're appointed that they have received, for example, the rules of being a GAL, that they know about the court policy, we give them the court schedule, how it works, things of that nature. And then we add to that file, for example, if we get letters of complaint against the attorney. And what I'll do is, a lot of times people will write in saying, I've tried to talk to my attorney, I've called 6 or 7 times, haven't gotten the first call back. You know, and that's really an ongoing problem for attorneys as a whole. You know, you just get going, you can't call people back. Well, when we start to get a lot of these letters, then we get concerned. So for one of these attorneys, each of us, ironically, we got 5 judges, we'd each gotten a couple of these. And so we finally all called this attorney in and met with him around the table and told him and shared with him our concerns and said, look, you're a good attorney, we want you on our list, but if this continues, then we're going to take you off the list. And to a lot of these people, this is, means a very good income. And so he was able to go about 6 months, and we didn't get any more complaints. Then we started to get a couple more back in. So at this point, we've taken him off one of our lists, and so he may be headed toward coming off the other one also. But so be careful about that, and respond to people. If you have to eat crow and apologize, you do. You be the bigger person with your clients and say, look, I'm sorry. Now, I'm not going to sit here and tell you that, clients have no or have a clue about your workday. No, I'd come back some days from being in court all day when I was practicing and see that one client had called 6 or 7 times and left that many messages. And after a while, you could see the frustration building and the type of message I was seeing from the client. Why don't I call them back? And they were already told I was in court all day. So, those you can't do much with. But even so, I would just suggest try and use a little, sweetness when you're talking to them rather than blast them. And a lot of times you'll send them a bill and they'll complain, and I don't know how often I would eat a bill just because I felt like if I went back and tried to sue them on the bill, I'd have a bar complaint. Perfectly, and that's what happens a lot of times. So just be careful, cover yourselves that way, be responsible to your clients. All right, thank you.
I would follow up on that with respect to making sure that you stay in touch with your client. Also, make sure that you're staying in touch with opposing counsel. Return your colleagues' telephone calls. Even if it's 6, 7 o'clock at night, return those telephone calls. There are so many complaints that could be cut off by simply communicating either with the client or with opposing counsel. And you don't want to be in the position where somebody is saying to a judge at a hearing, I could not schedule a deposition, I could not schedule a hearing, I could not do this or that because I could not get in touch with my opponent on the other side. You don't want to be in that. You don't want to be that person. So make certain that you do return those phone calls. I'm happy to open it up for any discussion, any issues that you have experienced and would like some guidance on how to handle, or any questions that you might have about anything that anyone has said here this afternoon about civility and professionalism.
I got one final thought.
Okay.
Before you turn anything into the court from your client, be sure you've reviewed it and know what it says. Don't be surprised if by what the client may have sent in, and if you hadn't reviewed it, it could be trouble. But I did have a case where, in many instances where juveniles might, let's say, take something from Walmart, I'll tell them, and given this particular case, the juvenile acted up with a police officer, tried to resist, all that. I said, I want you to write a letter of apology to the police officer for your conduct. Well, so he takes a sheet of paper, and the print is probably 3 inches for each letter, and it says, to that police officer, I apologize for cursing and for trespassing at such and such mall, from, and then he signs his name. And then he had a second page. P.S. God is going to get you for lying like you did. You're a bad person. And this is true. And so I couldn't believe it, but that's the type of thing. Just, be careful what goes to the court. Be sure you have a chance to run it through your hands so that you don't walk in at a dispositional hearing a few months later and I whip this thing out and you have no idea what was in it. But that type of thing, I'm big on attitude too. So I was a big Vince Lombardi fan and, loved his discipline and all that. And so I make my kids a lot of times look up Vince Lombardi quotes and pick 5 of them and tell me something about it, just so they get some idea of that teamwork and mental toughness and all that. But anyway, beside the point, I just would encourage you, keep up with what your clients are sending in. Thank you.
I know that Judge Soden and I both would welcome any comments that you have. If you want to send us something by way of email, we'll be glad to answer your questions if we can. If you are in Roanoke, please don't hesitate to stop by and say hello. If you're practicing in the neighboring jurisdiction, sometimes I find myself in Southwest Virginia. If that happens to be where you will be practicing, please don't hesitate to stop by and tell me that you were attending this particular session. I'd be glad to talk with you about any questions that you might have. So good luck in the practice of law. I look forward to seeing you in the courtroom. Thank you.